This is an ABC News special report. The impeachment trial of President Donald Trump. Now reporting, George Stephanopoulos.
Good afternoon and welcome to our special coverage of the Senate trial of President Trump. The president's legal team set to close their arguments today. They're right there in the well of the Senate for a couple of hours. As the big question on the table, the one that's been there for the last week or two, will the Senate call witnesses after they've heard these arguments from both legal teams? Of course, in the wake of John Bolton's revelation Sunday night in the New York Times, it seemed to shake up the Senate in a somewhat different situation this morning. So I want to bring it out in our senior congressional correspondent, Mary Bruce. And I think, Mary, Sunday morning, it looked like Senate Republicans had blocked any effort to call witnesses. Yesterday morning, it seemed like a complete shift. I think today it's fair to say no one has any idea.
Yeah, George, there is a lot of pressure on these Republicans. There's also a lot of spin going around the Capitol this morning, but there are not a lot of answers as to what is ultimately going to happen on this question of witnesses. Here's what we do know. We now have this handful of key moderate Republicans who seem increasingly likely that they will want to hear from John Bolton. We also know that the Republican leader, Mitch McConnell, is essentially urging all of his members to take a breath, to stay the course, and see how this conversation plays out. We are also now beginning to see some of the president's top allies here on the Hill floating what seems to be a potential compromise to try and win back some of these Republicans who are on the fence on the question of witnesses. We have heard from Lindsey Graham this morning, one of the president's top defenders here on the Hill, saying that perhaps they should make the classified manuscript available to all senators so that they can get a better sense of Bolton's perspective here. Then, of course, you have the Democrats, who meanwhile are simply trying to keep up the pressure on these Republicans, trying to keep the Bolton allegations in the conversation, because, George, a vote on whether or not to call witnesses is not likely to happen until Friday, and certainly a lot can change here between now and then.
And John Karl, thank you, Mayor. John Karl over at the White House, something we've seen before. The president not exactly on the exact same page as his advisors. In public, he seemed almost a bit resigned to the idea of witnesses, while his aides are pressing very hard behind the scenes to block them.
All-out push from the White House team to try to block this vote on witnesses, George. They feel pretty good about where they are. They're making the case that if you go with witnesses, you're going to prolong the trial and you're not going to change the outcome. That's the case they're making. Although it is interesting, we heard from John Kelly, his former chief of staff, gave a speech down in Florida and was and addressed this issue of John Bolton. He said that he believes John Bolton. If John Bolton said that, I believe John Bolton. And for his part, he said that he'd like to see witnesses.
And I want to bring that to Terry Moran, because, Terry, it's one of these things that we always talk about how different these times seem to be. We now have the president's former chief of staff saying he believes his former national security advisor is taking on the president directly. We've seen similar statements in the past several months from his former secretary of state, from his former defense secretary. And now these comments, as earth-shaking as they might be in other times, whether the White Houses are just another day at the office.
Yeah, that's a great point. It would be a shattering crisis of confidence in the president if his former chief of staff said, essentially, the president's lying, it looks like, because I believe the other guy. The president has said that John Bolton is absolutely incorrect. He never said anything like that, essentially calling Bolton a liar. And here's John Kelly, the president's former chief of staff, taking Bolton's side. These are very strange times. And I think one of the things we're seeing the Senate Republicans count on is run out the clock on the news cycle, that by Friday, we'll be on to something else.
And the Chief Justice is now in the chamber. Let's listen in.
Let us pray. O God, you are our rock of safety. Protect us in an unsafe world. Guard us from those who smile but plan evil in their hearts. Use our senators to bring peace and unity to our world. May they permit godliness to make them bold as lions. Give them a clearer vision of your desires for our nation. Remind them that they borrow their heartbeats from you each day. Provide them with such humility, hope, and courage that they will do your will. Lord, grant that this impeachment trial will make our nation stronger, wiser, and better. We pray in your strong name. Amen.
Amen. Please join me in reciting the Pledge of Allegiance to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please be seated. If there is no objection, the journal of proceedings of the trial are approved to date. Without objection, so ordered. The Sergeant-at-Arms will make the proclamation.
Good, thank you. Hear ye, hear ye, hear ye. All persons are commanded to keep silent on pain of imprisonment while the Senate of the United States is sitting for the trial of the articles of impeachment exhibited by the House of Representatives against Donald John Trump, President of the United States.
Mr. Chief Justice.
The Majority Leader is recognized.
We expect several hours of session today with probably one quick break in the middle.
Thank you. Pursuant to the provisions of Senate Resolution 483, the Counsel for the President have 15 hours and 33 minutes remaining to make the presentation of their case, though it will not be possible to use the remainder of that time before the end of the day. The Senate will now hear you.
Thank you, Mr. Chief Justice. Members of the Senate, just to give you a very quick, brief overview of today, we do not intend to use much of that time today, Mr. Chief Justice. We intend to be, our goal is to be finished by dinner time and well before. We'll have 3 presentations. First will be Pat Philbin, Deputy White House Counsel. Then Jay Sekulow will give a presentation. We'll take a break if that's okay with you, Mr. Leader, and then after that, I'll finish with a presentation. So that's our goal for the day. And with that, I'll turn it over to Pat Philbin.
Mr. Chief Justice, members of the Senate, Majority Leader McConnell, Minority Leader Schumer, I'd like to start today by making a couple of observations related to the abuse of power charge in the first article of impeachment. And I wouldn't presume to elaborate on Professor Dershowitz's presentation from yesterday evening, which I thought was complete and compelling, but I wanted to just add a couple of very specific points in support of the exposition of the Constitution and the impeachment clause that he set out. And it begins from a focus on the point in the debate about the impeachment clause at the Constitutional Convention, where maladministration was offered by George Mason as a grounds for impeachment. And James Madison responded that that was a bad idea. And he said, so vague a term will be equivalent to a tenure during the pleasure of the Senate. And that evinced a deep-seated concern that Madison had, and it's part of the whole design of our Constitution, for ways that can lead to exercises of arbitrary power. The Constitution was designed to put limits and checks on all forms of government power. Obviously, one of the great mechanisms for that is the separation of powers, the structural separation of powers in our Constitution. But it also comes from defining and limiting powers and responsibilities, and a concern that vague terms, vague standards are themselves an opportunity for the expansion of power and the exercise of arbitrary power. And we see that throughout the Constitution and in the impeachment clause as well. And this is why, as Gouverneur Morris argued in discussing the impeachment clause, that only few offenses, he said, few offenses ought to be impeachable, and the cases ought to be enumerated and defined. And that's why we see in the debates at the Constitution, there was many terms had been included in earlier drafts when it was narrowed down to treason and bribery, and there was a suggestion to include maladministration, which had been a ground for impeachment in English practice, the framers rejected it because it was too vague. It was too expansive. It would allow for arbitrary exercises of power. And we see throughout the Constitution in terms that relate and fit in with the impeachment clause the same concern. One is in the definition of treason. The framers were very concerned that the English practice of having a vague concept of treason that was malleable and could be changed even after the fact to define new concepts of treason was dangerous. It was one of the things that they wanted to reject from the English system. So they defined in the Constitution very specifically what constituted treason and how it had to be proved. And then that term was incorporated into the impeachment clause. Similarly, in the rejection of maladministration, which had been an impeachable offense in England, the framers rejected that because it was vague. A vague standard, something that's too changeable, that can be redefined, can be malleable after the fact, allows for the arbitrary exercise of power. And that would be dangerous to give that power to the legislature as a power to impeach the executive. And similarly, and it relates again to the impeachment clause, one of the greatest dangers from having changeable standards that existed in the English system was bills of attainder. Under a bill of attainder, the Parliament could pass a specific law saying that a specific person had done something unlawful, they were being attainted, even though it wasn't unlawful before that. And the framers rejected that entire concept. In Article 1, Section 9, they eliminated both bills of attainder and all ex post facto laws for criminal penalties at the federal level, and they also included a provision to prohibit states from using bills of attainder. Now, in the English system, there was a relationship to some extent between impeachment and bills of attainder because both were tools of the Parliament to get at officials in the government. You could impeach them for an established offense, or you could pass a bill of attainder. And it was because the definition of impeachment was being narrowed that George Mason at the debate suggested, and he pointed out, in the English system, there's a bill of attainder. It's been a great useful tool for the government, but we're eliminating that, and now we're getting a narrow definition of impeachment. We ought to expand it to include maladministration. And Madison said no, and the framers agreed. We have to have enumerated and defined offenses, not a vague concept, not something that can be blurry and interpreted after the fact, and that could be used essentially to make policy differences or other differences like that the subject of impeachment. All of the steps that the framers took in the way they approached the impeachment clause were in terms of narrowing, restricting, constraining, enumerating offenses, and not a vague and malleable approach as there had been in the English system. And I think the minority views of Republican members of the House Judiciary Committee at the time of the Nixon impeachment inquiry summed this up and reflected it well, because they explained, and I'm quoting from the minority views in the report, the whole tenor of the framers' discussions, the whole purpose of their many careful departures from English impeachment practice was in the direction of limits and of standards. An impeachment power exercised without extrinsic and objective standards would be tantamount to the use of bills of attainder and ex post facto laws, which are expressly forbidden by the Constitution and are contrary to the American spirit of justice. And what we see in the House managers' charges and their definition of abuse of power is exactly antithetical to the framers' approach, because their very premise for their abuse of power charge is that it is entirely based on subjective motive, not objective standards, not predefined offenses, but the president can do something that is perfectly lawful, perfectly within his authority. But if the real reason, as Professor Dershowitz pointed out, that's the language from their report, the reason in the president's mind is something that they ferret out and decide is wrong, that becomes impeachable. And that's not a standard at all. It ends up being infinitely malleable. And it's something that I think a telling factor that reflects how malleable it is and how dangerous it is in the House Judiciary Committee's report. Because after they define their concept of abuse of power, and they say that it involves your exercising government power for personal interest and not the national interest, and it depends on your subjective motives, they realize that that's infinitely malleable. There's not really a clear standard there. And it's violating a fundamental premise of the American system of justice, that you have to have notice of what is wrong. You have to have notice of an offense. And this is something that Professor Dershowitz pointed out last night. There has to be a defined offense in advance. And the way they try to resolve this is to say, well, in addition to our definition, high crimes and misdemeanors involve conduct that is recognizably wrong to a reasonable person. And that's their kind of add-on to deal with the fact that they have an unconstitutionally vague standard. They don't have a standard that really defines a specific offense. They don't have a standard that really defines in coherent terms that are going to be identifiable what the offenses are. So they just add on, and it's got to be recognizably wrong. And they say that they're doing this to resolve a tension, they call it, within the Constitution. Because they point out, and this is quoting from the report, the structure of the Constitution, including its prohibition on bills of attainder and the ex post facto clause, implies that impeachable offenses should not come as a surprise. And that's exactly what Professor Dershowitz pointed out. And everything about the terms of the Constitution, speaking of an offense and a conviction, that it's all crimes should be tried by jury except impeachments, they all talk about impeachment in those criminal offense terms. But the tension here isn't within the Constitution, it's between the House manager's definition, which lacks any coherent definition of an offense that would catch people by surprise, and the Constitution. That's the tension that they're trying to resolve, is between their malleable standard that actually states no clear offense and the Constitution and the principles of justice embodied in the Constitution that require some clear offense. So I wanted to point that out in relation to the standards for impeachable offenses, because it's another piece of the constitutional puzzle that fits in with the exposition that Professor Dershowitz set out. And it also shows an inherent flaw in the House manager's theory of abuse of power, regardless of whether or not one accepts the view that an impeachable offense has to be a crime, a defined crime. There is still the flaw in their definition of abuse of power, that it is so malleable, based on purely subjective standards, that it does not provide any cognizable notice of an offense. It is so malleable, it in effect recreates the offense of maladministration that the framers expressly rejected, as Professor Dershowitz explained. The second point that I wanted to make is that how do we tell, under the House manager's standard, what an illicit motive is, or when there's an illicit motive? How are we supposed to get the proof of what's inside the president's head? Because, of course, motive is inherently difficult to prove, where you're talking about, as they've conceded, they're talking about perfectly lawful actions on their face within the constitutional authority of the president, but they want to make it impeachable if it's just the wrong idea inside the president's head. And they explain in the House Judiciary Committee report that the way we'll tell if the president had the wrong motive is we'll compare what he did to what staffers in the executive branch said he ought to do. So they say, quote, that the president, quote, disregarded United States foreign policy towards Ukraine, end quote, and that he ignored, quote unquote, official policy that he had been briefed on, and that he, quote, ignored, defied, and confounded every agency within the executive branch, end quote. That is not a constitutionally coherent statement. The president cannot defy agencies within the executive branch. Article 2, Section 1 of the Constitution vests all of the executive power in a president of the United States. He alone is an entire branch of government. He sets policy for the executive branch. He's given vast power. And of course, within limits set by laws passed by Congress and within limits set by spending priorities, spending laws passed by Congress. He, within those constraints, sets the policies of the government. And in areas of foreign affairs, military affairs, national security, which is what we're dealing with in this case, foreign affairs, head of state communications, he has vast powers. As Professor Dershowitz explained, for over 2 centuries, the president has been regarded as the sole organ of the nation in foreign affairs. So the idea that we're going to find out when the president had the wrong subjective motives by comparing what he did to the recommendations of some interagency consensus among staffers is fundamentally anti-constitutional. It inverts the constitutional structure. And it's also fundamentally anti-democratic, because our system is rather unique in the amount of power that it gives to the president. The executive here has much more power than in a parliamentary system. But part of the reason that the president can have that power is that he is directly democratically accountable to the people. There is an election every 4 years to ensure that the president stays democratically accountable to the people. But those staffers in these supposed interagency who have their meetings and make recommendations to the president are not accountable to the people. There is no democratic legitimacy or accountability to their decisions or recommendations. And that is why it is the president, as head of the executive branch, who has the authority to actually set policies and make determinations, regardless of what the staffers may recommend. They're there to provide information and recommendations, not to set policy. So the idea that we're going to start impeaching presidents by deciding that they have illicit motives if we can show that they disagreed with some interagency consensus is fundamentally contrary to the Constitution and fundamentally anti-democratic. So those were the 2 observations I wanted to add to supplement specific points on Professor Dershowitz's comments from last night. Now I want to shift gears and respond to a couple of points that the House managers have brought up that are really completely extraneous to this proceeding. They involve matters that are not charged in the articles of impeachment. They do not relate directly to the president or his actions. But they are accusations that were brought up somewhat recklessly in any event, and we cannot close without some response to them. And the first has to do with the idea that somehow the White House and White House lawyers were involved in some sort of cover-up related to the transcript of the July 25th call because it was stored on a highly classified system. So let me start with that. The House managers made this accusation there was something nefarious going on. But let's see what the witnesses actually had to say. Lieutenant Colonel Alexander Vindman, and remember, Lieutenant Colonel Vindman is the person who was listening in on the call and who raised a concern, the only person who went and raised a concern with NSC lawyers that he thought there was something improper, something wrong with the call, even though he later conceded under cross-examination it was really a policy concern, but he thought there was something wrong. And he had to say that he did not think, he said, "So I do not think there was malicious intent or anything of that nature to cover anything up." He's the one who went and talked to the lawyers. He's the one whose complaint spurred the idea that, wait, there might be something that's really sensitive here. We should make sure that this is not going to leak. He thought there was nothing covering it up. His boss, Senior Director Tim Morrison, had similar testimony.
So to the best of your knowledge, there's no malicious intent in moving the transcript to the compartmented server?
Correct.
And the idea that there was some sort of cover-up is further destroyed by the simple fact that everyone who, as part of their jobs, needed access to that transcript still had access to it, including Lieutenant Colonel Vindman. Right? So the person who raises a complaint still has access to the transcript the entire time. And this is the way Mr. Morrison's testimony explained that.
And even on the code word server, you had access to it.
Yes.
So at no point in time during the course of your official duties were you denied access to this information?
Correct.
Is that correct? And to your knowledge, anybody on the NSC staff that needed access to the transcript for their official duties always was able to access it, correct? People that had a need to know and a need to access it?
Once it was moved to the compartmented system?
Yeah.
Yes.
Okay.
Now, as Mr. Morrison testified, he had recommended restricting access to the transcript, not because he had any concern that there was anything improper or illegal, but he was concerned about a potential leak, and as he put it, how that, quote, would play out in Washington's polarized environment, end quote, and would, quote, affect the bipartisan support our Ukrainian partners currently experience in Congress. And he was right to be concerned potentially about leaks because the Trump administration has faced national security leaks at an alarming rate. Lieutenant Colonel Vindman himself said that concerns about leaks seemed justified, and it was not unusual that something would be put in a more restricted circulation. Now, what else is in the record evidence? Mr. Morrison explained his understanding of how the transcript ended up on that server.
I spoke with the NSC Executive Secretariat staff, asked them why, and they did their research, and they informed me it had been moved to the higher classification system at the direction of John Eisenberg, whom I then asked why. I mean, if that was the judgment he made, that's not necessarily mine to question, but I didn't understand it. And he essentially told me I gave no such direction. He did his own inquiry, and he represented back to me that it was, his understanding was that it was a kind of administrative error, that when he also gave direction to restrict access, the Executive Secretariat staff understood that as an apprehension that there was something in the content of the MEMCON that could not exist on the lower classification system.
So to the best of your knowledge, there's no malicious intent in moving the transcript to the compartmented server?
Correct.
Everyone who knew something about it and who testified agreed there was no malicious intent. The call was still available to everyone who needed it as part of their job, and it certainly wasn't covered up or deep-sixed in some way. The president declassified it and made it public. So why we're even here talking about these accusations about a cover-up when it's a transcript that was preserved and made public is somewhat absurd. Now, the other point I'd like to turn to, another accusation from the House managers, is that the whistleblower complaint, when the whistleblower complaint was not forwarded to Congress, they've said that lawyers at the Department of Justice this time, they accuse OLC, the Office of Legal Counsel, of providing a bogus opinion for why the Director of National Intelligence did not have to advance the whistleblower's complaint to Congress. And Manager Jeffries said that OLC opined, quote, without any reasonable basis that the acting DNI did not have to turn over the complaint to Congress, end quote. And the way he portrayed this, now there's a statute that says if the Inspector General of the intelligence community finds a matter of urgent concern, it must be forwarded to Congress. And Manager Jeffries portrayed this as if the only thing to decide was were these claims urgent. He said, quote, what could be more urgent than a sitting president trying to cheat in an American election by soliciting foreign interference? That's not the only question. The statute doesn't just say if it's urgent, you have to forward it. It talks about urgent concern as a defined term. Now, if the House managers want to come and cast accusations at the political and career officials at the Office of Legal Counsel, which we all know is a very respected office of the Department of Justice, provides opinions for the executive branch on what governing law is, they should come backed up with analysis. So let's look at what the law actually says. And I think we have the slide of that. Urgent concern is defined as a serious or flagrant problem, abuse, violation of law, relating to the funding, administration, or operation of an intelligence activity within the responsibility and authority of the Director of National Intelligence involving classified information. So the Office of Legal Counsel was consulted by the General Counsel at the DNI's office, and they looked at this definition, and they did an analysis, and they determined that the alleged misconduct is not an urgent concern within the meaning of the statute. Because they're not just talking about, do we think it's urgent, do we think it's important? No, they're analyzing the law. And they looked at the terms of the statute. The alleged misconduct is not an urgent concern within the meaning of the statute because it does not concern the funding, administration, or operation of an intelligence activity under the authority of the DNI. Remember, what we're talking about here is a head of state communication between the President of the United States and another head of state. This isn't some CIA operation overseas. This isn't the NSA doing something. This isn't any intelligence activity going on within the intelligence community under the supervision of the DNI. It's the head of the executive branch exercising his constitutional authority, engaging in foreign relations with a foreign head of state. So in reaching that conclusion, the Office of Legal Counsel looked at the statute, the case law, the legislative history, and it concluded that this phrase, urgent concern, includes matters relating to intelligence activities subject to the DNI's supervision, but it does not include allegations of wrongdoing arising outside of any intelligence activity or outside the intelligence community itself, and that makes sense. This statute was meant to provide for an ability of the Inspector General of the intelligence community, overseeing the activities of the intelligence community, to receive reports about what was going on at intelligence agencies, those that are members of the intelligence community, if there was fraud, waste, abuse, something unlawful in those activities. It was not meant to create an Inspector General of the presidency, an Inspector General of the Oval Office, to purport to determine whether the president, in exercising his constitutional authorities, had done something that should be reported. This law is narrow, and it does not cover every alleged violation of law, OLC explained, or other abuse that comes to the attention of a member of the intelligence community. Just because you're in the intelligence community and happen to see something else doesn't make this law apply. And the law does not make the Inspector General for the intelligence community responsible for investigating and reporting on allegations that do not involve intelligence activities or the intelligence community. Now, nonetheless, the President, of course, released the July 25th call transcript. And it was also not the end of the matter that the whistleblower complaint and the DNI, the ICIG's letter were not sent directly to Congress, because OLC explained that if the complaint does not involve an urgent concern, but if there's anything else there that you want to have checked out, the appropriate action is to refer the matter to the Department of Justice. And that's what the DNI's office did. They sent the ICIG's letter with the complaint to the Department of Justice. And the Department of Justice looked at it. And this was all made public some time ago. The Department of Justice examined the exact allegations of the whistleblower and the exact framing and concern raised by the Inspector General, which had to do with a potential of perhaps a campaign finance law violation. DOJ looked at it, looked at the statutes, analyzed it, and determined there was no violation, and it closed the matter. And it announced that months ago. All right, when something gets sent over to the Department of Justice to examine, you can't call that a cover-up. Everything here was done correctly. The lawyers analyzed the law. The complaint was sent to the appropriate person for review. It was not within the statute that required transmission to Congress. And everything was handled entirely properly. So again, actually extraneous to the matters before you, There's nothing about these 2 points in the articles of impeachment, but it merits a response when reckless allegations are made against those at the White House and at the Department of Justice. And with that, Mr. Chief Justice, I'll yield back my time to Mr. Sekulow.
Thank you, Mr. Chief Justice. Majority Leader McConnell, Democratic Leader Schumer, House managers, members of the Senate. What we are involved in here, as we conclude, is perhaps the most solemn of duties under our constitutional framework. The trial of the leader of the free world and the duly elected President of the United States. It is not a game of leaks and unsourced manuscripts. That's politics, unfortunately, and Hamilton put impeachment in the hands of this body, the Senate, precisely and specifically to be above that fray. This is the greatest deliberative body on earth. In our presentation so far, you've now heard from legal scholars from a variety of schools of thought, from a variety of political backgrounds. But they do have a common theme with a dire warning: danger, danger, danger. To lower the bar of impeachment based on these articles of impeachment would impact the functioning of our constitutional republic and the framework of that Constitution for generations. I asked you to put yourself, and I was quoting Mr. Schiff's, Manager Schiff's statement his father made about putting yourselves in the shoes of someone else, and I said, I'd like you to put yourself in the shoes of the President. And I think it's important as we conclude today that we're reminded of that fact. The President of the United States, before he was the President, was under an investigation. It was called Crossfire Hurricane. It was an investigation led by the FBI, the Federal Bureau of Investigation. James Comey eventually told the President a little bit about the investigation and referenced the Steele dossier. James Comey, the then director of the FBI, said it was salacious and unverified. So salacious and unverified that they used it as a basis to obtain FISA warrants. Members, managers here, managers at this table right here, said that any discussions on the abuse from the Foreign Intelligence Surveillance Act utilized to get the FISA warrants from the court were conspiracy theories. I told you at the very beginning, I asked, do you put yourselves in the shoes of not just this president, of any president that would have been under this type of attack? FISA warrants issued on people affiliated with his campaign, American citizens affiliated with people of his campaign, citizens of the United States being surveilled pursuant to an order that has now been acknowledged by the very court that issued the order, that it was based on a fraudulent presentation. In fact, evidence specifically changed by the very FBI lawyer who was in charge of this. Changed to such an extent that the Foreign Surveillance Intelligence Court, as I said earlier, I'm not going to repeat it again, issued 2 orders saying that when this agent, this lawyer, made these misrepresentations to the National Security Division, they also made a misrepresentation to a federal court, the federal court, the Foreign Surveillance Court, a court where there are no defense witnesses, a court where there is no cross-examination. It's a court based on trust. That trust was violated. And then the director of the Federal Bureau of Investigation, James Comey, decides he will leak a memo of a conversation he had with the President of the United States. And he is leaking the memo for a purpose, he said, to obtain the appointment of a special counsel. And lo and behold, a special counsel was appointed. And it just so happens that that FBI agent, lawyer, who committed the fraud on the FISA court became a lawyer for the Mueller investigation, only to be removed because of political animus and bias found by the Inspector General. Then we have a special counsel investigation. Lisa Page, Agent Strzok, I'm not going to go into the details. You know them. They're not in controversy, they're uncontroverted. The facts are clear. But does it bother your sense of justice even a little bit, that Bob Mueller allowed the evidence on the phones of those agents to be wiped clean while there was an investigation going on by the Inspector General? Now, if you did it, Manager Schiff, if you did it, Manager Jeffries, if I did that, destroyed evidence, if anyone in this chamber did this, we'd be in serious trouble. Their serious trouble is they get fired. Bob Mueller's explanation for it is, I don't know what happened. I don't know what happened. I can't recall the conversations. You can't view this case in a vacuum. You are being asked, and I say this with the utmost respect, you are being asked to remove an duly elected president of the United States. This isn't some, we had references to law school exams, and I love the fact that I thought there were great analysis yesterday, and I appreciate all of that. But I want to focus today, or my section, on what you're being asked to do. You are being asked to remove a duly elected president of the United States, and you're being asked to do it in an election year. In an election year. There are some of you in this chamber right now that would rather be someplace else. And that's why we'll be brief. I understand. You'd rather be someplace else. Why would you rather be someplace else? Because you're running for president, the nomination of your party. I get it. But this is a serious deliberative situation. You're being asked to remove a duly elected president of the United States. That's what the articles of impeachment call for, removal. So we had a special counsel, and we got the report. And just for a moment, putting yourselves in the shoes of this president or any president that would be under this situation, you're number 4 at the Department of Justice. His wife is working for the firm that's doing the opposition research on him and is communicating with the foreign former spy, Christopher Steele, to put together the dossier, and it's being handled by Christopher Steele through Nellie Orr to her husband, then the fourth-ranking member at the Department of Justice, Bruce Orr, and all of this is going on. And he doesn't want to tell, and he's testified to this, he doesn't want to tell everybody what he's doing because he's afraid he might have to stop. Might have to stop. How did this happen? This is the Federal Bureau of Investigation. And then we ask, why is the president concerned about advice he's being given? Put yourself in his shoes. Put yourself in his shoes. We've given you, and our approach has been, to give an overview and to be very specific. To remove a duly elected president, which is what you're being asked to do, in essentially policy disagreements. You heard a lot about policy. Although the one that it still troubles me. This idea that the president, it was said by several of the managers, is only doing these things for himself. Understanding what is going on in the world today as we're here. They raised it, by the way. I'm not trying to be disrespectful. They raised it. This president is only doing things for himself while the leaders of opposing parties, by the way, at the highest level, to obtain peace in the Middle East, to say you're only doing that for yourself. I think the irony of that those statements were made while all of that was going on, and other acts that this body's passed, some of it bipartisan, to help the American people. Policy differences. Those policy differences cannot be utilized to destroy the separation of powers. House managers spoke for, I know we've had disagreements on the time, if it was 21 hours or 23 hours. They spoke during their time, a lot of time. Most of it attacking the president, policy decisions. They didn't like what they heard. They didn't like there was a pause on foreign aid. I laid out before that there was pauses on all kinds of foreign aid. It's not the first president to do it. But the one thing I'm still trying to understand from the manager's perspective, and maybe it's not fair to ask the managers because you're not the leader of the House, but remember the whole idea that this was a dire national security threat, a danger to our nation? We had to get this over here right away. It had to be done before Christmas. It was so important. It was so significant. The country was in such jeopardy. The jeopardy was so serious that it had to be done immediately. Let's hold on to the articles of impeachment for a month to see if the House could force the Senate to adopt rules that they wanted, which is not the way the Constitution is set up. But it was such a dire emergency. It was so critical for our nation's national interest that we could hold them for 33 days. Danger, danger, danger. That's politics. As I said, you're being called upon to remove the duly elected president of the United States. That's what these articles of impeachment call for. They never really answer the question of why they thought there was such a national emergency. Maybe they will during questions, I don't know. There was such a national emergency, they never did explain why it was that they waited. They certainly didn't wait to have the proceedings as my colleagues have laid out. I mean, those proceedings moved in record time. I suspect that we've been here more than the House actually considered the actual articles of impeachment. Is that the way the Constitution is supposed to work? Is that the design of the Constitution? And then their question, of course, came up and yesterday on the whole situation with Burisma and the Bidens and that whole issue. And my colleagues went through that a great deal, and I'm not going to do that. But do we have are we in a situation, we used to call this in free speech cases like a free speech zone. You could have your free speech activities over here. You can't have them over there. Do we have like a Biden-free zone? I mean, was that what this was? You mention someone or you're concerned about a company and it's now off limits. You can impeach the President of the United States for asking a question. I think we significantly showed the question. I'm not going to go through a detail-by-detail analysis of the facts, but there are some that we just have to go through. You heard a lot of new facts yesterday in our presentation. Saturday, what we were pointing to is a very quick overview. And then yesterday, we spent the day, and we appreciate everybody's patience on that, going through the facts. They showed you this, but they didn't show you that. The facts are important, though, because facts have legal ramifications. Legal ramifications impact the decisions you make. So I don't take facts lightly, and I certainly don't take the constitutional mandate lightly, and we can't. The facts we demonstrated yesterday and briefly on Saturday demonstrate that there was, in fact, a proper governmental interest in the questions that the President asked and the issues that the President raised on that phone call. A phone call. Now, let's, again, put your feet in the shoes of the President. Put yourself in the President's position. Do you think he thought when he was on the call it was him and President Zelensky he was talking to and that was it? Or it was, as sometimes I heard one commentator said, it was people listening in on the call, the President and 3,000 of his closest friends. Let's be realistic. The President of the United States knew when he was on that call there were a lot of people listening from our side and from their side. So he knew what he was saying. He said it. We released a transcript of it. The facts on the call that have been kind of the focus of all of this really focused on foreign policy initiatives both in Ukraine and around the globe. They talked about other countries and other countries. The President has been very concerned about other countries carrying some of the financial load here, not just the United States. That's a legitimate position for a president to take. If you disagree with it, you have the right to do that. But he is the president. As my colleague, Deputy White House Counsel Philbin just said, that's the executive branch prerogative. That is their constitutional appropriate role. So the call is well documented. There were lots of people on the call. The person that would be on the other end of the quid pro quo, if it existed, would have been President Zelensky. But President Zelensky, and we already laid out the other officials from Ukraine, have repeatedly said there was no pressure. It was a good call. They didn't even know there was a pause in the aid. All of that is well documented. I'm not going to go through each and every one of those facts. We did that over the last several days. President Zelensky's senior advisor, Andrei Yermak, was asked if he ever felt there was a connection between military aid and the request for investigations, and he was adamant that we never had that feeling, and we did not have the feeling that this aid was connected to any one specific issue. This is coming from the people who were receiving the aid. So we talk about this whole quid pro quo, and that was a big issue. That's how this actually, before it became a impeachment proceeding, there was, as the proceedings were beginning in the House Permanent Select Committee on Intelligence under Chairman Schiff's role, there was all these discussions. Is it a quid pro quo? Was it extortion? Was it bribery? What was it? And we are clear in our position that there was no quid pro quo. But then yesterday, my co-counsel, Professor Alan Dershowitz, explained last night that these articles must be rejected. He's talking about from a constitutional framework, even if there was a quid pro quo, which we have clearly established there was not. And this is what he said, and I'm going to quote it verbatim. The claim that foreign policy decisions can be deemed abuses of power based on subjective opinions about mixed or sole motives that the president was interested only in helping himself demonstrate the dangers of employing the vague, subjective, and politically malleable phrase abuse of power as a constitutionally permissible criteria for the removal of a president. He went on to say, now it follows from this that if a president, any president, were to have done what the Times reported about the content of John Bolton's manuscript, that would not constitute an impeachable offense. I'm quoting exactly from Professor Dershowitz. He says, let me repeat it. Nothing in the Bolton revelations, even if true, would rise to the level of abuse of power or an impeachable offense. That is clear from history. That is clear from the language of the Constitution. You cannot turn conduct that is not impeachable into impeachable conduct simply by using words like quid pro quo and personal benefit. It is inconceivable that the framers would have intended to so politically loaded and promiscuously deployed a term as abuse of power to be weaponized, again, Professor Dershowitz, as a tool of impeachment. It is precisely the kind of vague, open-ended, and subjective term the founders and the framers feared and rejected. Now, to be specific, you cannot impeach a president on an unsourced allegation. But what Professor Dershowitz was saying, even if everything in there was true, it constitutionally doesn't rise to that level. But I want to be clear on this, because there's a lot of speculation out there. With regard to what John Bolton has said, which referenced a number of individuals, we'll start with the president. Here's what the president said in response to that New York Times piece. I never told John Bolton that the aid to Ukraine was tied to investigations into Democrats, including the Bidens. In fact, he never complained about this at the time of his very public termination. If John Bolton said this, it was only to sell a book. The Department of Justice. While the Department of Justice has not reviewed Mr. Bolton's manuscript, the New York Times account of his conversation grossly mischaracterizes what Attorney General Barr and Bolton discussed. There was no discussion of personal favors or undue influence on investigations, nor did the Attorney General state that the President's conversations with foreign leaders were improper. The Vice President's Chief of Staff issued a statement. In every conversation with the President and the Vice President, in preparation for our trip to Poland, remember that was the trip that was being planned for the meeting with President Zelensky, the President consistently expressed his frustration that the United States was bearing the lion's share of responsibility for aid to Ukraine and that European nations weren't doing their part. The President also expressed concerns about corruption in Ukraine, and at no time did I hear him tie Ukraine aid to investigations into the Biden family or Burisma. That was the response. Responding to an unpublished manuscript that maybe some reporters have an idea of maybe what it says. That's what the evidence, if you want to call that evidence, I don't know what you'd call that. I'd call it inadmissible, but that's what it is. To argue that the President is not acting in our national interest and is violating his oath of office, which the managers have put forward, is wrong, based on the facts and by the way the Constitution is designed. And when you look at the fullness of the record of their witnesses, the witnesses' statements, the transcripts, there's one thing that emerges. There is no violation of law. There's no violation of the Constitution. There is a disagreement on policy decisions. Most of those that spoke at your hearings did not like the president's policy. That's why we have elections. That's what policy differentials and differences are discussed. But to have a removal of a duly elected president based on a policy disagreement, that is not what the framers intended. And if you lower the bar that way, danger, danger, danger. Because the next president, or the one after that, he or she will be held to that same standard? I hope not. I pray not, that that's not what happens. Not just for the sake of my client, but for the Constitution. You know, Professor Dershowitz gave a list of presidents from Washington to where we are today, who under that standard that they are proposing could be subject to abuse of power or obstruction of Congress. Look, we know that what this is not about a president pausing aid to Ukraine. It's really not about a phone call. It's about a lot of attempts on policy disagreements that are not being debated here. My goodness, how much time? How much time has been spent in the House of Representatives they were hoping, that the Mueller probe would result in, I'm not going to play you, I was thinking about it, playing all the clips from all the commentators the day after Bob Mueller testified. Bob Mueller was unable to answer under his examination basic and fundamental questions. He had to correct himself, actually. He had to correct himself before the Senate for something he said before the House. So that's what the president's been living with. And then we're here today arguing about what? A phone call to Ukraine? Or Ukraine aid being held? Or a question about corruption? Or a question about corruption that happens to involve a high public profile figure? I mean, is that what this is? Is that where we are? And then what do we find out? The aid was released. It was released in an orderly fashion. The reform president, President Zelensky, wins, but there was a question whether his party would take the parliament. It did. They worked late into the evening with the desire to put forward reforms. So everybody was waiting, including, and you heard the testimony from, I will say, their witnesses. You heard the testimony. Everybody was concerned about Ukraine. Everybody was concerned about whether these reforms could actually take place. Everybody was concerned about it. So you hold back. Didn't affect anything that was going on in the field. We heard Mr. Crow worrying about the soldiers. I understand that. I appreciate that. But none of that aid was affecting what was going on the battlefield right then or for the next 4 months because it was future aid. And are we having an impeachment proceeding because aid came out 3 weeks before the end of the fiscal year? Or a 6-minute phone call? You boil it down, that's what this is. It's interesting to me that everybody's saying, well, the aid was finally released September 11th, only because of the committee and the whistleblower who we've never seen. Mr. Philbin dealt with that in great detail. I'm not going to go over that again. But you know, the new high court, the anti-corruption court, wasn't established and did not sit until September 5th, 2019. So while the president of Ukraine was trying to get reforms put in place, the court that was going to decide corruption issues was not set until September 5th. I want you to think about this for a moment, too. They needed a high court of corruption for corruption. I mean, think about that for a moment. Now, that's good that they recognized it. But remember when I said the other day, you don't wave a magic wand and now Ukraine doesn't have a corruption problem? The High Court of Corruption, which they have to have, because there's not just past corruption, they're concerned about ongoing corruption issues. And you could put all of your witnesses back under oath in the next hearings you'll have when this is all over. And you're going to be back in the House and we'll be doing this again. Put them all back under oath and ask them, Mr. Schiff, is there a problem of corruption in Ukraine? And if they get up there and say, no, everything is great now, hallelujah. But I suspect they're going to say, we're working really hard on it. And I believe them. But this idea that it was just vanished and now we're back into everything's fine, it's absurd. Mr. Morrison testified that while the developments were taking place, the vice president also met with President Zelensky in Warsaw. That was the meeting of September 1st. The one, by the way, where the vice president's office said, in response to this New York Times, nobody told him about aid being held or linked to investigations. Are you going to stop? Are you going to allow proceedings on impeachment to go from a New York Times report about someone that says what they hear is in a manuscript? Is that where we are? I don't think so. I hope not. What did Morrison say? He heard firsthand that the new Ukraine administration was taking concrete steps to address corruption. That's good. He advised the president that the relationship with Zelensky is one that could be trusted. Good. President Zelensky also agreed with Vice President Pence, this is interesting, that the Europeans should be doing more. And related to Vice President Pence, conversations he'd been having with European leaders about getting them to do more. In sum, the president raised two issues he was concerned with to get them addressed. Now, I've already went over, again, this is just the closing moments here of this proceeding, of our portion of this proceeding. Aid was withheld or paused, put on a pause button, not just for Ukraine. Afghanistan, South Korea, El Salvador, Honduras, Guatemala, Lebanon, and Pakistan, and I'm sure I am leaving countries out. But do you think the American people are concerned if the president says, you know, before we give a country, I don't know, $550 million, some countries only $400 million, we'd like to know what they're doing with it. You're supposed to be the guardians of the trust here. It's the taxpayers' money we're spending. There was a lot of testimony from Dr. Fiona Hill, John Bolton's deputy. Here's what she said about aid that was being held. This is her testimony. There was a freeze put on all kinds of aid and assistance because it was in the process at the time of an awful lot of reviews of foreign assistance. Oh, you mean there was a policy within the administration to review foreign assistance and how we're doing it because we spend a lot of money. And by the way, I'm not complaining about the money. I don't think anybody doesn't want to help. But we do need to know what's going on. And those are valid and important questions. Manager Crow told you that the president's Ukraine policy was not strong against Russia. But Ambassador Yovanovitch stated the exact opposite. She said in her deposition that our country's Ukraine policy under President Trump actually, her words, got stronger than it was under President Obama. So again, policy disagreements, disagreements on approach. have elections. That's what we do in our republic. For 3 long days, House managers presented their case by selectively showing parts of testimony. Good lawyers show parts of testimony. You don't have to show the whole thing. But other good lawyers show the rest of the testimony. And that's what we sought to do, to give you a fuller view of what we saw as the glaring omissions by my colleagues, the House managers. The legal issues here are the constitutional ones. And I have been, I think, pretty clear over the last week, starting when we had the motions arguments, that my concern about the constitutional obligations that we're operating under. I have been critical of Manager Nadler's executive privilege and other nonsense. I want you to look at it this way. Take out executive privilege. First Amendment free speech and other nonsense. The free exercise of religion and other nonsense. The rights to due process and other nonsense. The rights to equal protection under the laws and other nonsense. You can't start doing that. You would not do that. No administration has done that. In fact, since the first administration, George Washington, they wanted information. He thought it was privilege. He said it was executive privilege. But let's not start calling constitutional rights other nonsense, lumping them together. Of course, this is from a House of Representatives that actually believes the attorney-client privilege doesn't apply, which should scare every lawyer in Washington, D.C. But more scary to the lawyers would be for their clients. They say that in writing, in letters. They don't hide it. I would ask them, I'm not going to, it's not my privilege to do that. Do you really believe that? Do you really believe that the attorney-client privilege does not apply in a congressional hearing? Do you really believe that? Because then if it doesn't apply, then there is no attorney-client privilege. Or is that the attorney-client privilege and other nonsense? Danger, danger, danger. We believe that Article 1 fails constitutionally. The President has constitutional authority to engage and conduct foreign policy and foreign affairs. It is our position, legally, the President at all times acted with perfect legal authority, inquired of matters in our national interest, and having received assurances of those matters, continued his policy that his administration put forward of what really is unprecedented support for Ukraine, including the delivery of military aid package that was denied to the Ukrainians by prior administrations. You know, some of the managers right here, my colleagues at the other table, voted in favor of those, wanted Javelin anti-tank missiles for Ukraine. Some of the members here did not. Didn't want to do that. Voted against that. I'm glad we gave it to them. I'm glad we allowed them to purchase Javelins. I tell you, I never served in the military. I have tremendous, tremendous respect for the men and women that protect our freedom each and every day. Tremendous respect for what they are doing and continue to do. But this president actually allowed the Javelins to go. Some of you liked that idea, some of you did not. It's a policy difference. Were you going to impeach President Obama because he did not give them lethal aid? No, nor should have you. You should not do that. It's a policy difference. Policy difference do not rise to the level of constitutionally mandated or constitutional applications for removal from office. It is policy differences. By the way, it's not just on lethal weapons. And President Obama, as I said, withheld aid. He had the right to do that. You've allowed him to do that. Oh, but we don't like that this president did it, so the rules change. So this president's rules are different than, he has a different set of standards he has to apply than what you allowed the previous administration to apply, and you know what? Or the future administration to apply. That's the problem with these articles. We've laid out, I believe, a compelling case on what the Constitution requires. When they were in the House of Representatives putting this together, did they go through a constitutionally mandated accommodations process to see if there was a way to come up with something? No, they did not. Did they run to court? No. And the one time it was about to happen, they ran the other way. Separation of powers means something. It's not separation of powers and other nonsense. If we've reached now, at this very moment, in the history of our republic, a bar of impeachment because you don't like the president's policies or you don't like the way he undertook those policies, because we hear a lot about policies. If partisan impeachment is now the rule of the day, which these members and members of this Senate said should never be the rule of the day. My goodness, they said it, some of them 5 months ago. But then we had the national emergency. A phone call. It's an emergency. Except we'll just wait. But if partisan impeachment based on policy disagreements, which is what this is, and personal presumptions, or newspaper reports and allegations in a unsourced, maybe this is in somebody's book who's no longer at the White House, that becomes the new norm. Future presidents, Democrats, Republicans, will be paralyzed the moment they are elected, before they can even take the oath of office. The bar for impeachment cannot be set this low. Majority Leader McConnell, Democratic Leader Schumer, House managers, members of the Senate. Danger, danger, danger. These articles must be rejected. The Constitution requires it. Justice demands it. Majority Leader, we would ask for a short recess if we can, about 15 minutes.
The Majority Leader is recognized.
We'll be in recess for 15 minutes.
Without objection.
Passionate presentation there from Jay Sekulow, the president's lawyer, saying danger, 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 repeated that refrain several times. So the danger is lowering the bar for impeachment. Also argued that these senators cannot look at this case in a vacuum. And in fact, he and the other White House counsel, Pat Philbin, spent much of their time arguing about things that aren't at issue in these articles of impeachment. Pat Philbin talking about the whistleblower and how the transcript of the rough transcript of the phone call was handled back in July 25th inside the White House. Jay Sekulow talking a fair amount about the Mueller report, the Crossfire Hurricane investigation of President Obama and James Comey, before he got to the meat of his argument, which is basically, he says, that the president should not be impeached for policy differences and then taking on the Bolton allegations, which, of course, have rocked this impeachment trial over the last 24 hours, calling them unsourced allegations in a newspaper, and also repeating Alan Dershowitz's argument, the president's other attorney from last night, that even if everything Bolton alleges is true in that manuscript, it would not be impeachable. I want to take that to Mary Bruce, our senior congressional correspondent. I was actually surprised he didn't harp more on that point, Mary, because Republicans I was talking to said that was the most effective argument in their mind last night when Alan Dershowitz said, even if Bolton's telling the truth, it's not impeachable.
Yeah, that did seem to get a warm reception from many Republicans here on the Hill. So it is surprising that that wasn't hammered more. And I have to tell you, George, I was in the chamber during these remarks from Sekulow, and it was striking that he did mention in a not so subtle way Bolton's allegations here, but it was sort of indirect, right? Sekulow saying at the top of his remarks that this is not a game of leaks and unsourced manuscripts. And I can tell you from my vantage point, I could actually see over Sekulow's shoulder, and he was actually tweaking the top of his remarks, striking things out, making notes up until the final moment. And then, of course, he took to the lectern and made those very comments. In the room, it is notable that while senators are paying attention, far fewer senators actually seem to be taking copious notes, with the exception of those standouts that we've been talking about all week long. Susan Collins is just writing nonstop. And another name stood out to me, Senator Bill Cassidy of Louisiana, also appeared to be paying very close attention today. Mitt Romney, of course, who we've been talking about a lot, who says he wants to hear from John Bolton. He's been the most outspoken on this. He actually appeared slightly unamused during some of Sekulow's more political comments as he continued to speak. But the most activity that I saw is happening at the House managers table and at the Trump team table. Sekulow had a lot of criticisms for the House managers. They did not engage. They did not make eye contact. They continue to make a lot of notes because, of course, George, we know they are preparing for their opportunity to respond to some of these allegations that are coming and some of the arguments that the Trump team has been making, and, of course, to try and litigate, essentially, the Bolton allegations during the question and answer portion that will come starting tomorrow.
And Mary, you mentioned Bill Cassidy, that senator from Louisiana. Interesting that you brought him up because it was reported that yesterday at the Senate lunch, he was actually seemed to be reinforcing the argument of some of the senators who were calling for witnesses. Yet I had been told by some sources this morning that they thought he was back in the president's fold.
Yeah, he is one of those that we are now keeping a very close eye on here. It's not clear exactly which side of this he is on at the moment. We know that he has raised some concerns behind closed doors. Others have said that he is actually leaning away from calling for additional witnesses. So we're just going to have to see where he lands. But it does raise this question about a domino effect that some Democrats certainly are hoping for, and some Republicans have been concerned about, that if you start to see other key Republicans calling for additional witnesses, well, will you see more than just the four that Democrats need to be successful, but will you actually see others come out as well?
Thank you, Mary. Tamaran, let me bring that question to you that I was raising with Mary at the beginning. It seemed like when Jay Sekulow kept talking about these unsourced allegations, perhaps in a manuscript described to the New York Times, that it was kind of an argument against interest, because if you're a senator listening, I could say, okay, well, let's talk to him.
It seemed like he just laid out the red carpet for John Bolton to walk in and give testimony to the Senate. If it's unsourced, the source is right there. The author, the person who says, according to this book, that Donald Trump did, in fact, want to use his power to muscle the Ukrainian government to investigate Joe Biden. Now, one of the things that the Republicans have become enchanted by is Alan Dershowitz's article that even if that were true, that wouldn't be an impeachable offense because it's not a statutory crime. There are plenty of people who can go over why specific framers, Alexander Hamilton, James Madison, and others, explicitly denied that impeachment had to be a statutory crime. But one gets the unmistakable feeling that if the shoe were on the foot, they'd argue the other way. Those are the times that we live in. If there's a Democratic president who abuses power in such a way that Republicans feel it is impeachable but not criminal, I guarantee the arguments will go the other way.
Tara Moran, thank you. Cecilia Vega here with me, our senior White House correspondent. We saw the president tweet at one point during Jay Sekulow's, as I said, passionate presentation, praising that passion right there. And at times, it seemed like Jay Sekulow, particularly at the beginning of his presentation, it was like a summary of the president's Twitter feed over 2019.
A greatest hits list, I think we would call it. And it certainly also seemed at times that he was speaking to that ever so famous audience of one. We know now from Twitter that the president definitely was watching, as you said, praising his performance. To me, this felt like a dance that we have seen come out of this administration before. This was a present the pattern of alternative facts, as they like to call them. They say that this was all about a phone call. George, we have to remind our viewers, this wasn't just about a phone call. The nonpartisan government GAO found that this was not right when they withheld this aid, that in fact a law was in fact broken. So this wasn't just about a phone call. This isn't just about what they call unsourced allegations. This is about actual laws, a law that was broken and proven to be by this nonpartisan group that's out there.
Yeah, let's talk to our legal panel about this right now. Kate Shaw, it did seem like the arguments today, and we'll see what Pat Cipollone has to say when he closes the arguments for the president's team, as much political as legal.
I think that's right. And, you know, I don't think it's that unusual to see lawyers make arguments in the alternative, right? So he didn't do what he's accused of having done, and even if he did, it's not impeachable, right? So you see these arguments in the law, but I did think it was interesting that the team didn't lean further into that argument that this just isn't impeachable, even if everything that Bolton has alleged is true. And I have to believe it's in part because the polling suggests that the public thinks that this conduct, if proven, was wrong. And so I imagine that the president is sending, you know, explicitly or implicitly, who knows, directives to his team not to concede that all of these allegations from Bolton are true.
The only time you've seen that, Dan Abrams, was last night. Robert Ray, one of the president's attorneys, came as close as any of the anybody on the president's legal team to saying, even if you think what he did was wrong, it's not an impeachment.
But I think that us lawyers are viewing this too much through a legal prism. There is no question that is the strongest legal argument here. It's not the argument the president wants to hear. He knows, at least as of right now, there's almost no chance that the Senate is convicting him. He wants to be exonerated. He doesn't want a good legal argument. And I think you're seeing that because if you were going to put a headline on Jay Sekulo's performance, it would be, the president has been victimized. That was the sort of the big picture of what the argument is here. Talking about the FISA warrants and Robert Mueller, and you can't view it in a vacuum, and going through each and every grievance that the president has had. Some of them more accurate than others. And by the way, I thought that his performance was very powerful. I thought he was a very effective advocate. But when you actually dig into some of the facts, on some of these, there's really no there. But it is something that the president wants mentioned. And so to just look at this and say, well, it would have been stronger to say, let's just focus on the one aspect of it, I think you'd have a very disappointed client.
and who is obviously watching. Pierre Thomas, let me bring in your senior justice correspondent. One of the other things that Jay Sekulow mentioned, he mentioned as he was talking about the Bolton allegations, the fact that Bolton had alleged that he talked to the Attorney General, William Barr, about his concerns about the phone call and Rudy Giuliani's dealings in Ukraine. He just repeated Barr's denials.
He did, in fact. And just to be clear here, the Justice Department is rejecting all the claims emanating from this transcript of the book that's coming up to be released pretty soon. The Justice Department is categorically denying it. And I think that one of the things that we have to look at here is the context of Bolton calling the Attorney General, the chief law enforcement officer in the country, and basically making allegations against the President of the United States, George. I think that in itself was just extraordinary.
It was something to see. John Carl, the White House has also, led by the president, been denying these Bolton allegations.
Absolutely. The president flatly denying the allegations, suggesting that Bolton is simply trying to get attention for his book. That allegation has been made more pointedly from the Republican National Committee, from the president's supporters. It's really fascinating, George, to see the president's supporters, and to a degree the president himself, essentially call the man who served as his national security advisor for 17 months a liar and somebody who is simply trying to drum up publicity to sell a book and make some money.
And, John, where's the White House? What have they been saying about this idea floated by Senator Lankford and others, including backed by Senator Graham, that maybe the senators, perhaps in the SCIF, in the secure facility inside the Capitol, take a look at the Bolton manuscript?
You know, there's no formal statement on that yet, but my sense from the White House team is that's something that they would certainly consider. But, George, I don't think it's something that would satisfy the Democrats in any way. They don't want to see John Bolton's book. They want to talk to John Bolton. They want to see the underlying documents. They want to see John Bolton's notes from these conversations. They want to see what he said in emails about this. There's no drumbeat from Democrats to see a book that's about to be published by John Bolton.
John, thank you. I want to go back to Mary Bruce on Capitol Hill. We haven't been seeing the usual parade of senators come out and address the cameras during this break.
No, and George, it is notable because, of course, the Republican leader here, Mitch McConnell, has essentially urged all of his members to take a breath, right, to see where these Bolton allegations lead, where the conversation goes. So we have seen a notable sort of clampdown from senators here throughout the day. They aren't being as talkative as they normally are. And something notable inside the chamber just now, our Trish Turner, who's in there, noticed that two of those key moderate Republicans we have been talking about so much, Susan Collins and Lisa Murkowski, are huddled off to the side, just the two of them, talking very intently, almost, she said, with their hands held up to their heads as if to try and shield reporters in the room from being able to see what they are discussing. They are currently in a very intense conversation, it seems, perhaps discussing what they just heard.
Mary, we've all been trying to read tea leaves, and the senators have all been incredibly careful with their words over the last several days. I think it's fair to say that Susan Collins and Mitt Romney have been the ones most forward-leaning on the idea of witnesses. Next would be Lisa Murkowski, who said she's still curious about John Bolton, and then seemed to take another step in the direction of witnesses today, but not all the way.
Yeah, exactly. If you're sort of looking at these four key senators that we've been paying so much attention to on a bit of a scale, Mitt Romney is certainly the most outspoken in support of calling witnesses. He has said flat out he wants to hear from John Bolton. Susan Collins has made very clear that she is also supportive of this. She says she always wants more information, not less. That same standard would apply to John Bolton. And then you mentioned Lisa Murkowski. She has said yesterday, after these allegations came out, and again today, underscoring that she is curious to hear what more Bolton may have to say, but she's not quite as far along as the others. Lamar Alexander of Tennessee, another one that we have been paying very close attention to. He, of course, is holding his cards much closer to the vest. And so while there's been a lot of movement here on the Hill, it's been a lot of movement, it seems, within this same group. And so right now, the bottom line is that Democrats still haven't been able to summon enough support. They still don't have 4 Republican senators who are enough tilting the scale to be able to call these witnesses, and it seems perhaps Mitt Romney and Susan Collins, maybe are discussing these things amongst themselves. Also of interest, we spotted today Lindsey Graham, of course, the president's top ally here on the Hill, speaking privately with both Mitt Romney and Susan Collins separately on the floor before the Republicans' argument got underway this morning.
We are seeing some Democratic senators now come to the microphones. Richard Blumenthal of Connecticut.
Calling witnesses.
Do I think Republicans have the votes to stop calling witnesses?
Right.
Based on this summation, a fact-free summation filled with innuendo and insinuation, there's no way that the president can continue blocking witnesses with any sort of integrity, and there's no way that my colleagues can continue to be complicit if they failed to hear evidence. What you just saw was a fact-free summation of a case bereft of evidence. We need the evidence. We need the witnesses and documents. They may have the votes at this moment, but I hope my colleagues will look themselves in the mirror and look at how they will be viewed by history and by their constituents.
And what do you think of the one-for-one?
Terry Moran, some strong words there from Richard Blumenthal, but he may have buried the lead. He said about 6 sentences in, they may have the votes at the moment.
They may have the votes to block the calling of witnesses. And once again, it does raise questions about the Democratic strategy to fast-track an impeachment before Christmas. That book was on its way to the White House. Slow and steady, even maybe taking cases to court. That would be out in the House of Representatives now, and maybe building public support. Right now, the trial is heading towards a conclusion. And that vote on witnesses, which is Richard Blumenthal says, does not look at this point like it will go the way that the House managers and Democrats want, and will not lay down a record in the Senate trial of what we know to be the facts. That is coming our way, and it will raise questions, I think, with historians and perhaps with voters about how the House of Representatives, House Speaker Nancy Pelosi handled this impeachment.
John Carl, let's talk a little bit about that fourth Republican Senator, Lamar Alexander. He's described as being somewhat cross-pressured. Of course, he is retiring from the Senate. He's also a close colleague of Mitch McConnell, one of his closest allies in the Senate, yet he's consistently reminded that he holds the seat of Howard Baker, Republican of Tennessee, who famously, in the end, took on Richard Nixon during the Watergate proceedings. Describe a little bit about the position he's in and what we should know about him.
Well, first of all, he's a guy with an incredible biography. He was president of the University of Tennessee. He was the governor of Tennessee, of course, senator, ran for president, and he was a real protege of Howard Baker. He doesn't simply sit in his seat. He also has the office building, the office that was once held and used by Howard Baker. He worked for Howard Baker. He revered Howard Baker, and Howard Baker showed ultimately independence during the Nixon impeachment process, and that is his role model. So that alone leads to speculation that he sees himself in this process as somebody who is going to be truly independent and look at it outside of the political context. As you mentioned, he's not running for re-election. He doesn't. It just doesn't matter, in terms of the politics to him. But he has said nothing that really indicates that he is ready to vote for witness. He's kept his cards very close to his chest. Really hasn't said much of anything about it. But he is, clearly one of those, maybe even the decisive vote on this. If the other three all voted for witnesses, you would need Howard Baker to be the fourth vote.
One of the few.
I'm sorry, you would need Lamar Alexander, to be the fourth vote. Yes.
One of the few substantive things he has said is that the House managers have actually presented overwhelming evidence, which could kind of cut either way on the question of witnesses. Pierre Thomas, one of the other things that senators at least have to consider as they're making this vote, a political consideration, not a legal consideration, as they're making this vote, is what kind of information could come out after the vote. And Terry addressed what could have been coming out during a House impeachment proceeding. What we still have going on are a couple of court cases dealing with immunity, the president's claims of immunity for his aides, and of course the Southern District's here in New York, their investigation that now includes Rudy Giuliani, the president's lawyer.
Absolutely, George. You have the Don McGahn situation, the former White House counsel, in terms of whether he can be compelled to testify. That is still pending. And as you said, the Southern District, which is investigating, according to our sources, Rudy Giuliani, a name that has not come up at all today. But last night, George, one of the things we took note of is that one of the counsel for the president talked about that he was a bit player. And again, I wondered how that played with the senators who can look at the transcript and see the president naming Giuliani as someone he wanted the president of Ukraine, Zelensky, to speak to, and that he wanted to speak to him clearly about it. So it's interesting in terms of what they're hearing, what they know the facts are, and how that's playing, George.
Cecilia Vega, this is already playing out on the campaign trail. Of course, the Iowa caucuses, Democratic Iowa caucus is coming up on Monday. Jay Sekulow only mentioned Biden's embracement in passing today. Of course, there was a major presentation yesterday picked up by the Republican Iowa Senator, Joni Ernst.
And she stepped out of the talking points and got herself in a little bit of hot water for it when she said that she was interested to see how these Biden comments would influence Iowa caucus voters and whether they will be supportive of Biden after they heard them. Of course, that the Democrats are saying that completely undercuts everything that the White House has been saying and trying to sell over the last few months, that this isn't about politics. This is all about corruption. But when Joni Ernst put this out there in a very public way, as some have said, she said what isn't supposed to be spoken among Republicans, that they completely violated that oath that they've taken, that this is about corruption, not about politics. And the Biden camp, of course, responded very quickly. They said that she said the quiet part out loud, that the Republicans are terrified that Biden is going to win this nomination and take on Donald Trump in the general election. But this really was an unabashedly political comment.
And let's bring this back as we discuss how far far and how long this could go. Kate, let's talk a little bit more about John Bolton. And first of all, we should say that there's nothing stopping him from coming out and speaking right now.
He could call a press conference, he could write an op-ed, he could do anything he wanted to. You know, he can't charge into the halls of the Senate unless he's actually called to testify there, but certainly he can speak. He's a private citizen right now. But, you know, so say there are the votes to get him to actually subpoena him, right, to call him to testify in the Senate. That's not likely the end of the story, right? It is at least possible that the president's team will go to court to seek to block Bolton from testifying, claiming either immunity or executive privilege. I think there's a very good chance a federal court would say, we're not supposed to weigh in on the processes that the Senate uses to try impeachments. There's one Supreme Court case involving the impeachment of a federal judge, basically saying, Senate, the impeachment process is for you to decide how to run, not for us. So courts may decide it's not to them at all to resolve these issues. But if they do decide to weigh in on questions of immunity and executive privilege, I think the White House is in a very difficult position attempting to block Bolton, in part because, as you say, he's a private citizen who wants to testify.
And Dan, it puts the Chief Justice in what could be a very strange situation. They could make a motion. Democrats can make a motion. Let's hear from John Bolton. He's going to say, I'm not going to rule on it.
Right.
Let's let the Senate rule. He gets another motion on executive privilege after the White House claims it says, I'm not going to rule on it. Yep. Let the Senate rule. Yet then if it goes to the court, it could be right back on his desk.
It absolutely could be. And remember, there's something else that could happen here, is the Democrats could say, all right, you guys want to litigate Bolton? This is a good time for us to litigate Mulvaney and Pompeo and Giuliani and everyone else.
When we can get a fast track.
Right. If we're going to fast track this thing, we'd like to hear from a whole bunch of other witnesses. I mean, remember, because of the argument that they're making here, which is he did nothing wrong. I mean, Jay Sekulow is outraged that the president has even been put in this position because he did absolutely nothing wrong. If that's the case, then you would think he would welcome the inner circle to come in and say he did nothing wrong. It didn't happen the way they're alleging. I didn't have the conversations that Gordon Sondland has alluded to, et cetera. You would think that they'd want to have those conversations, et cetera. That hasn't happened yet. But I do think that if we end up in the courts with Bolton, we may end up in the courts with more than just Bolton.
And Mary, that point, let me run this to you, Mary Bruce, that Dan was just making. What could be the Democrats' last chance to advance this argument is in these questions that are likely to occur over the next couple of days. And they are strategizing how to use this Bolton argument during the question time to put more pressure on the Republican senators on witnesses.
Yeah, George, they will now have up to 16 hours, senators, to question. And this is the only chance that the House managers, the Democratic prosecutors, will have not only to respond to the arguments that have been made over the last 24 hours by the president's team, but also it is their best chance to try and reinforce and litigate essentially these allegations from John Bolton. And we know that they are strategizing. They have been huddling. They have already actually been submitting, many senators already submitting questions, but they are going to have to game out how to best respond to the allegations from John Bolton and how best to try and keep the pressure up on these key moderate Republicans who seem to be on the fence, and to try and sway Republicans to join them in this call for additional witnesses, while also on the flip side trying to also respond to some of and rebut some of the comments and arguments made by the Trump team.
Terry Moran, you made a good point about the price the House may have paid by going so quickly back in December. I wonder what might also be on senators' minds right now. I noticed that Senator James Lankford this morning was urging John Bolton to come out and speak right now, because they at least have to be concerned. If they block the call for witnesses right now, John Bolton doesn't testify. They maintain this position that you just heard from Jay Sekulow. These are just unsourced allegations that on March 17th or before the whole book comes out with some damning allegations that they will have to answer for after their vote.
They will, and it is possible that Bolton not only has the conversation with President Trump, but notes, and it's possible that those notes and his contemporaneous recording of what President Trump was doing and saying could blow up the defense and make it look like it indeed was very corrupt. We'll have to see. And at that point, the senators who voted against listening to John Bolton, when it was out there to be had, might look like ostriches sticking their head in the sand. And that's not a good look with voters a lot.
And John, Carl, let's talk a little bit more about John Bolton. So much speculation about how this report was leaked on Sunday night, the same day as the president pointed out that his book went on advance sale on Amazon. He came out and said he'd be willing to testify if subpoenaed after the House finished their work. Describe the different motivations based on the man that he has, based on the man you know.
Well, first of all, Bolton has a reputation for being somebody with very hardline ideological positions, but somebody who tells the truth. He is seen as somebody, as somebody who worked with him put it, tells the truth to a fault. He is not somebody with a reputation for lying about something like this. And he has said categorically through his lawyer and his spokesperson that he did not leak this manuscript. That this manuscript, there was one copy of it, and it was the copy that was submitted to the White House for the required security review. Now, on the side of the White House officials have said that this manuscript went to the career professionals that reviewed such things to see if there was any classified information in it, and that the lawyers in the White House counsel's office who have been arguing in the case did not have access to it, were not familiar with the contents. So where did it come from? I mean, it's anybody's guess. On the question of it appearing for online sales just after the news broke in the New York Times, what the Bolton team says is they had absolutely nothing to do with that. The book was in the news, and Amazon.com, et cetera, they had an opportunity.
They're back in the chamber. Pat Cipollone, the president's lawyer.
But I think you've heard a lot from our side, and I think we've made our case. And so I just want to leave you with a couple of points. First of all, thank you, Mr. Leader, and thank you, Democratic Leader Schumer, and all of you for the privilege of speaking on the floor of the Senate and for your time and attention. We really appreciate it. We've made three basic points. One, all you need in this case is the Constitution and your common sense. You just look at the articles of impeachment. The articles of impeachment fall far short of any constitutional standard, and they are dangerous. And if you look to the words from the past that I think are instructive, as I said last night, they're instructive because they were right then and they're right now. And I'll leave you with some of those words.
There must never be a narrowly voted impeachment or an impeachment supported by one of our major political parties and opposed by the other. Such an impeachment will produce the divisiveness and bitterness in our politics for years to come, and will call into question the very legitimacy of our political institutions.
This is unfair to the American people. By these actions, you would undo the free election that expressed the will of the American people in 1996. In so doing, you will damage the faith the American people have in this institution and in the American democracy. You will set the dangerous precedent that the certainty of presidential terms, which has so benefited our wonderful America, will be replaced by the partisan use of impeachment. Future presidents will face election, then litigation, then impeachment. The power of the president will diminish in the face of the Congress, a phenomenon much feared by the founding fathers.
This is a constitutional amendment that we are debating, not an impeachment resolution. The Republicans are crossing out the impeachment standard of high crimes and misdemeanors, and they are inserting the words any crime or misdemeanor. We are permitting a constitutional coup d'etat, which will haunt this body and our country forever.
I warn my colleagues that you will reap the bitter harvest of the unfair partisan seeds you sowed today. The constitutional provision for impeachment is a way to protect our government and our citizens, not another weapon in the political arsenal.
I expect history will show that we've lowered the bar on impeachment so much. We have broken the seal on this extreme penalty so cavalierly. that it will be used as a routine tool to fight political battles. My fear is that when a Republican wins the White House, Democrats will demand payback.
You were right. But I'm sorry to say you were also prophetic. And I think I couldn't say it better myself, so I won't. You know what the right answer is in your heart. You know what the right answer is for our country. You know what the right answer is for the American people. What they are asking you to do is to throw out a successful president on the eve of an election with no basis and in violation of the Constitution. It would dangerously change our country and weaken forever all of our democratic institutions. You all know that's not in the interest of the American people. Why not trust the American people with this decision? Why tear up their ballots? Why tear up every ballot across this country? You can't do that. You know you can't do that. So I ask you to defend our Constitution, to defend fundamental fairness, to defend basic due process rights, but most importantly, to respect and defend the sacred right of every American to vote and to choose their president. The election is only months away. The American people are entitled to choose their president. Overturning the last election and massively interfering with the upcoming one would cause serious and lasting damage to the people of the United States and to our great country. The Senate cannot allow this to happen. It is time for this to end, here and now. So we urge the Senate to reject these articles of impeachment for all of the reasons we have given you. You know them all. I don't need to repeat them. They've repeatedly said over and over again, a quote from Benjamin Franklin, "It's a republic if you can keep it." And every time I heard it, I said to myself, it's a republic if they let us keep it. And I have every confidence in your wisdom. You will do the only thing you can do, what you must do, what the Constitution compels you to do. Reject these articles of impeachment for our country and for the American people. It will show that you put the Constitution above partisanship. It will show that we can come together on both sides of the aisle and end the era of impeachment for good. You know it should end. You know it should end. It will allow you all to spend all of your energy and all of your enormous talent and all of your resources on doing what the American people sent you here to do, to work together, to work with the president, to solve their problems. So this should end now, as quickly as possible. Thank you again for your attention. I look forward to answering your questions. And with that, that ends our presentation. Thank you very much.
Concise close there from the president's lawyer, Pat Cipollone, saying it's time to end the era of impeachment. Let's listen to the Majority Leader.
Mr. Chief Justice, I have reached an agreement with the Democratic leader on how to proceed during the question period. Therefore, I ask unanimous consent that the question period for senators start when the Senate reconvenes on Wednesday. Further, that the questions alternate between the majority and minority sides for up to 8 hours during that session of the Senate. Finally, that on Thursday, the Senate resume time for senators' questions alternating between sides for up to 8 hours during that session of the Senate.
Is there objection? Without objection, so ordered.
So we will complete the question period over the next 2 days. I remind senators that their questions must be in writing, will be submitted to the Chief Justice. During the question period of the Clinton trial, senators were thoughtful and brief with their questions, and the managers and counsel were succinct in their answers. I hope we can follow both of these examples during this time.
During the impeachment trial of President Clinton, Chief Justice Rehnquist advised counsel, quote, counsel on both sides, that the chair will operate on a rebuttable presumption that each question can be fully and fairly answered in 5 minutes or less, end quote. The transcript indicates that the statement was met with, quote, laughter, end quote. Nonetheless, managers and counsel generally limited their responses accordingly. I think the late chief's time limit was a good one and would ask both sides to abide by it.
So, Mr. Chief Justice, I ask unanimous consent that the trial adjourn until 1 p.m. Wednesday, January 29th, and that this order also constitute the adjournment of the Senate.
Without objection, we're adjourned.
I think we may have just seen the first bipartisan agreement of this impeachment trial right there on how to conduct the questioning that will take place over the next 2 days in the Senate. Questions from Democrat and Republican senators to the House impeachment managers and the president's lawyers. The senators will not speak, as you just heard right there. They will submit their questions in writing to the Chief Justice, who will read them to the person that they are addressed to. Then you'll see the responses. And the idea behind this bipartisan agreement that you just saw the Chief Justice ratify right there is that neither the managers nor the Trump team will filibuster in their answers as they go over these next couple of days before that key vote of witnesses on Friday. And we just came off, as I said, a concise presentation by the president's attorney, Pat Cipollone, basically not repeating any of his arguments right there, just repeating the phrase we first heard from Ken Starr talking about the age of impeachment, saying it must end, and using Democrats, I should say, from 1999 to make his case. Democrats arguing against the impeachment of President Bill Clinton, saying we shouldn't have a partisan impeachment, which, of course, is exactly what happened in the House in December. I want to go to Mary Bruce right now. Now all of the backstage lobbying begins over this question of whether to call witnesses on Friday.
And, George, we are already seeing that. Our reporters inside of the chamber tell us that there is some intense jockeying going in on the Senate floor, especially over, it seems, Lisa Murkowski. She was spotted huddling, speaking intensely with Susan Collins, who, of course, is another one of these key moderate Republicans who has said that she is leaning towards, it seems, calling John Bolton or supporting calling John Bolton to testify. They spent about 10 minutes chatting, just the two of them. And then, notably, it seems that Lisa Murkowski got an earful from the other side, which is she was spotted talking very closely with the Republican whip, Senator John Thune. He, of course, is essentially the arm twister up here, and he talked to her for at length, standing in the aisle together, just the two of them. It seems from the vantage point of our reporter Devin Dwyer in the room that they were discussing the issue of witnesses. Thune, in the last 24 hours, has said that if John Bolton does come up here, well, then he notes that opens the door for Republicans to also call witnesses they are interested in, like Joe Biden, like Hunter Biden, that it would prolong this trial significantly. I suspect that was probably an argument that he was reinforcing with Lisa Murkowski. And then Thune, it's also notable, he went and spoke with Senator Mitt Romney and then made his way up to speak to the Republican leader, Mitch McConnell. George, we are seeing the beginning of this kind of jockeying, these kinds of behind-the-scenes negotiations are only likely to intensify and continue here over the next coming days before we see a vote later this week.
Yeah, and the Republican conference is meeting tonight to go over this question as well. John Carl, we also saw Pat Cipollone, the president's attorney, touch lightly at the end on that argument that you might have just heard from John Thune as well. It's time for you senators to get back to work. That is clearly an argument that the White House is pushing behind the scenes as well.
Absolutely, and that witnesses would draw this out for two reasons. One, you would have legal challenges to those witnesses, and secondly, as you heard Mary mention, they're saying, well, if the Democrats are going to have witnesses, Republicans are going to have witnesses too, and this thing will be a long way from being over.
Kate Shaw, Dan Abrams, Cipollone's close. probably quite effective in deciding to be concise.
I think that's right. I think there was a lot of exhaustion in the chamber and maybe in the country at large that the Democrats' presentation took not the full 24 hours, but very close to that. It seems as though the White House has made the tactical decision to be
kept reminding the senators about that.
About how long the Democrats went on for. That's right. So, I think that he did end where Ken Starr began yesterday with this call to end the age of impeachment, to transcend partisanship. A little hard to swallow in that it's been a fairly partisan presentation at points that the president's team has made, but that at least is the note that they chose to end on.
And I think it was effective, the way that they used the old statements of Democrats from the Clintons. Yes, you can argue it's very different.
And of course, you could have pulled out a bunch of Republican statements.
And
exactly
they did.
Yeah,
and they did. When they pulled out Lindsey Graham,
right,
et cetera, and others. I think it's effective. It's effective in showing what feels like hypocrisy. And you can sit there and each one of them would have an explanation for why they said what they did, and it's different than it is today. But in a way to end the presentation, I think it worked.
But yeah, these deliberations over the next 24, 48 hours, pure politics.
Oh, yeah. I mean, look, it's all about witnesses. Let's be clear. I mean, these questions now, if the Democrats are smart, will focus only on the question of how do we get witnesses, and not the fundamental big picture question. Because as of right now, they've got no chance on the big picture. They've got a chance on witnesses.
They are going to go behind closed doors right now. We're going to return now to our regular programming. The cases have been presented by the Democrats and President Trump's legal team. As you just heard, tomorrow, questioning will begin from Republican and Democratic senators to the House impeachment managers and President Trump's legal team. We're going to be here for all that. We're going to start at 1 o'clock tomorrow. We will be back to cover the president's trial. And, of course, there'll be a full wrap-up tonight on World News Tonight with David Muir. Have a good afternoon.
This has been a special report from ABC News. ABC News, straightforward.